Now you are.
The Red Bank,
Yeah, you're good.
the Red Bank Planning Board will come to order this 25th day of June, 2023. 2025. Time is 7:04. Adequate notice of this meeting has been posted at the Borough Hall, filed with the Borough Clerk, and mailed to the Asbury Park Press and the Two River Times. No new cases will be heard after 10 p.m. The board will adjourn for recess at 8:30 p.m. The chairperson reserves the right to revise the order of the agenda as needed.
We need a roll call.
We need a roll call. Yes, thank you.
Mayor Portman, absent. Greg Fitzgerald, absent. Christina Bonatakis.
Present.
Emma Mancuso, absent. Lou Demento.
Here.
Barbara Boas.
Here.
Megan Massey.
Here.
Wilson Beebe, absent. Itzel Hernandez, absent. Fred Stone.
Here.
And Brian Parnigan, absent.
Administrative matters, meeting minutes from June 11th. We have
We need
enough,
a motion.
we need a motion to approve them. So moved.
Second.
And it
It
is.
can be all in favor.
All in favor?
Aye.
Aye.
Megan is abstaining.
Abstains, yeah.
And then we have the presentation.
You want to do the resolution, just get that over with?
Yes.
Yeah.
I didn't see it on the agenda.
It is on.
Yeah, that's fine. It needs to be that out. So, yeah, so
Over.
this is a resolution adopting the recommended redevelopment plan that the board voted in favor of at the last meeting. This is just the formal memorialization of that plan. And upon this, it will be transmitted to the mayor and council.
Motion.
We need a motion to approve.
Second, through. All right. Christina Bonatakis,
Yes.
Lou Demento,
Yes.
Barbara Boas.
Yes.
And Megan, you abstain. She's abstaining.
She has to abstain. Well, she's recused. She's not eligible to vote because she wasn't here.
And Fred Stone.
Yes.
Okay.
Okay.
Do I have to read this?
No, you just read that there's gonna be a presentation
Oh, there's going to be a presentation,
of the housing.
housing elements
And fair share plan.
and fair share plan. I can't find out. I forgot, I didn't know I was doing this. I don't have my reading, but it's necessary.
That's it.
All right.
Yes. You can come up.
And our presenter is,
Thank you. Knockney from CME Associates. So look, if I sit here, it looks like that's,
I sit there because that's the only mic.
all right. Thank you. Like I said, I'm Chris Dockney, a professional planner with CME Associates, and we've been contracted by the borough to prepare a housing plan element and fair share plan to satisfy your fourth round obligations for affordable housing, formerly known as COA or Mount Laurel housing, if you are more familiar with those terms. So I've got essentially, I think about 10 minutes, maybe 15 minutes to go through what affordable housing is, what the Fair Housing Act is, what Red Bank's obligations are under the Fair Housing Act, and what we're doing to satisfy those obligations. And largely then I anticipate most of this being more or less a question and answer session, depending on what questions you might have on the process or what's going to happen going forward. Because I submitted, I hope you all have had a chance to read through the copy, at least maybe not word for word, roughly 200 pages, the housing plan element and fair share plan. Like I said, it's about 200 pages. There's probably about 10 pages of actual meat and bones, relevant information in here that isn't just boilerplate discussion on affordable housing or, you know, I think there's about 25 pages of discussion of the demographics and economic conditions of the borough, which if you all live here, you're pretty well aware of what's going on. But anyway, so this is the housing plan element, which is technically an element of your master plan, which this board, as the planning board, has the exclusive jurisdiction to adopt. And then what the law generally encourages, not necessarily requires, is for housing plans that they like to see the governing body, which would be the borough council, endorse them by resolution as well, saying that they are on board with this plan, because As you're all aware, generally any master plan element, they're just a series of recommendations. They don't have the force of law. But the governing body, which is the only body in Red Bank that has the authority to adopt laws as ordinances, the state likes to see that the governing body is in step with the planning board, with the housing plan, so that any new laws that need to be enacted to implement the housing plan, to make sure that you're providing for your fair share of low and moderate income housing, that the governing body is going to follow up with what this plan says. So this presumably tonight you will adopt, because the state has given us all a deadline of June 30th to have a housing plan adopted. So today is what, the 26th? So we have essentially tonight's our only shot at this, to get this.
The 25th.
25th still up.
There's
I'm
give us one more day.
I'm eagerly awaiting for June to be done so I can move on to work that isn't affordable housing. I'm adding another day in my head, I guess, but 25th, but yeah, so where was I here? All right. So that's what the housing plan is. Just a brief overview, because I think I was here when we adopted the third round plan. I don't recall how many of these board members were on the board back in 2018 when that plan was adopted. So I'm just going to briefly go over what the Fair Housing Act is, the Mount Laurel Doctrine, essentially. So going back to well before I was born in the 60s, there was a group in Mount Laurel of essentially resident farmhands that wanted to build low-income housing for themselves. They'd gotten a grant through some sort of federal entity, or maybe it was even a nonprofit, I don't recall. They had gotten a grant to build themselves low-income apartments in Mount Laurel. And the town effectively changed their zoning before that application could go forward to say that all apartments and mobile homes and anything that would typically be lower income housing, naturally occurring lower income housing, is effectively banned from the town. So fast forward about 10 years from that, give or take, I think it was maybe 1975-ish, when the actual Supreme Court case went through with the NAACP of Southern Burlington County versus Mount Laurel. The NAACP is essentially arguing that it's unlawful or unconstitutional for the town of Mount Laurel to effectively ban low-income housing, and through their zoning code, put a price floor on being able to live in the community. The Supreme Court agreed with that, and we got us into the Mount Laurel 1 case that said towns have an obligation to essentially zone to allow some forms of lower moderate income housing, which would typically be things like apartments, townhouses, mobile homes, things like that. Not much happened in the 5 to 10 years after that. And then in 1983, we get the much more substantial Mount Laurel 2 case. Same exact town, NAACP of Southern Burlington County filed suit against Mount Laurel, saying that they had effectively not done what they were supposed to do after the Mount Laurel 1 case. They hadn't really amended their zoning in any meaningful way to allow for affordable housing to be built in town. So that the same group of people trying to build the same apartment complex still were not able to get the approvals they needed. So they sued again, and they won again at the Supreme Court level. And we got the Mount Laurel 2. And as a result of that, instead of simply a zoning ordinance that allows for forms of housing that are typically occupied by lower moderate income households, we also got the Fair Housing Act adopted by the state, and the courts taking over affordable housing, as well as through the Fair Housing Act, they had established the Council on Affordable Housing, COA. And as a result of that second case, instead of towns just having to zone to allow lower moderate income housing types, every town was essentially assigned a number of how many affordable units you had to proactively make sure there's room to create. Where previously the law had just been you have to zone to allow those forms of housing in some capacity. Now every town has a literal number that says you have 500 units or 200 or 300. You have to proactively demonstrate that you are accommodating that exact number of units and no less, as well as a host of other administrative actions that need to be taken in order to demonstrate compliance with the law. So we had Mount Laurel 2. There have been subsequent cases. I don't need to get into the Mount Laurel 3, Mount Laurel 4, and that stuff, but we have a new amended Fair Housing Act that was signed into law last March by the governor that set new procedures for how to calculate every town's numbers for the fourth round, which we're now in the fourth round of affordable housing. The first rounds were, I believe, 87 through 99, and then 99 through 2025 was the third round. So we're starting the fourth round next month, which is 2025 through 2035. And through the methodology outlined in a 2015 court case in Mercer County, as well as in the amended Fair Housing Act, there's a pretty complex calculation that needed to take place at the state level and regional level. And then that sort of filters down through every municipality in the state of how you calculate what your fair share obligation is and how many units of affordable housing are required in each town. So in accordance with the Fair Housing Act, DCA, the New Jersey Department of Community Affairs, they calculated that for every town in New Jersey. Their calculations were not binding, though. They were estimates and put forward, and towns could essentially accept them or reject them and do their own calculations. Red Bank accepted those calculations, which DCA calculated, I believe it was 154 unit obligation for Red Bank for the fourth round, and the borough accepted that, and in January of this year, adopted a resolution accepting those numbers, saying that we agree with the DCA's report on the numbers, and we're going to plan to address this 154 unit obligation. Like I said, so this is the fourth round. Just briefly, I'll get into the prior rounds. And rounds 1 and 2, which is 83 through 99, the borough had a 427 unit obligation for affordable housing. However, at that time, the borough qualified for what's known as a vacant land adjustment. The laws do allow for towns that don't have sufficient vacant and open land to address whatever their affordable housing obligation numbers are. You can adjust that to a more realistic development potential, and then you have to plan for whatever that the RDP, the realistic development potential, you have to plan to accommodate that, and then do some additional planning, some additional zoning for what they call the unmet need. At the time, COA, which was still in place at the time, had agreed that Red Bank had a realistic development potential of 0. So from 87 through 99, the courts and COA, the state essentially recognized that Red Bank as a fully built out community with no large tracts of vacant land, unlike places like, say, Mount Laurel, or a little bit more in the country or in more suburban locations where there is lots of large tracts of vacant land that the law originally targeted. Like, as Mount Laurel originally started from farmhands who wanted to build apartments on the farms they were working in. Red Bank doesn't have that. Red Bank's been built out for a long time. There's not really any vacant property here that's more than a quarter acre, if that. I think even less than that. So the court said you had a realistic development potential at the time of 0, but you did have to plan for some affordable housing to address some of what's called the unmet need, which is that 427 unit obligation, but you weren't required to satisfy all of it. Nonetheless, there were a handful of projects in place at the time. I think some of them might have even been built before that. Some of them built during that time, that addressed 163 affordable units towards that unmet need. And then the third round, which was 1999 through 2025, since that the laws on calculating the methodology for what everyone's numbers were essentially in court for 15 to 20 years. The state didn't essentially settle on what everyone's third round obligation numbers were until 16 years into the third round. So like I said, 99 to 2025, but most towns didn't have their obligation numbers established until around 2015, 2016, because the methodology that COA had adopted was rejected by the courts a little bit later. And then COA stopped functioning, so no one came up with a methodology, and then it all just went to lawsuits. And so there was literally a decade of lawsuits over affordable housing. Not necessarily the Red Bank was involved individually in those lawsuits, but they were lawsuits at the state level. And so it was around 2017, we had petitioned the court and got a settlement agreement with Fair Share Housing Center, which is an affordable housing advocacy group that sort of intervened on behalf of low and moderate income households all across the state. And so the third round was essentially a negotiation with Fair Share Housing Center to determine what your numbers were and how you're going to address those numbers, and then that would be approved by the court. So we went through that process from 2016 through 2018, and maybe finally got it approved by the court in 2019. At a 313 unit obligation at that time. And even though largely the borough was still built out, there was not vacant land at the time. The court master and the courts and Fair Share Housing Center didn't necessarily accept a realistic development potential of 0 like it was in the prior round, but it had a negotiated settlement of 92 unit realistic development potential. And that was fully satisfied through a handful of projects, including the 176 Riverside redevelopment project, Riverwalk Commons, Fortune Square, the Yellowbrook project, Azalea Gardens, Cedar Crossing, a group home, and then some bonus credits, which are eligible to get. So of that realistic development potential of 92, that was satisfied through 99 credits, which were then applied to that obligation, as well as the unmet need. And that a big part of that settlement was what you have in place at the time right now is the sliding scale ordinance of anytime anybody comes before this board or the zoning board, if they're going to the zoning board for a use variance. If anybody has more than 5 units of housing in a multifamily project, they have to provide an affordable housing set aside. And then so we have that sliding scale of depending on how big the project is, the larger the affordable housing obligation is that they have. And this board and the zoning board as well has been doing that. So as a result of that, largely, we have already essentially satisfied our fourth round obligation. Like I said, our fourth round obligation, 154 units, is the obligation as calculated by DCA and accepted by the borough. What we have calculated, we've gone through the exercise of doing a vacant land adjustment again to obviously not a lot of vacant land or virtually no vacant land in Red Bank. Through our calculations, we think your realistic development potential, since what I've found is you really only have one property in town that is vacant and available and is not encumbered by wetlands or some sort of other environmental issue, or is not, publicly owned and used for borough purposes. The law requires we go through every piece of vacant land as well as every piece of publicly owned property. So things like Borough Hall here has to be reviewed to see if there's development capacity on this property. We calculate your realistic development potential to be 1 unit of affordable housing that you would need to satisfy between 2025 and 2035. However, through projects that have already been approved or are already in the pipeline, we would essentially fully satisfy that 154 unit obligation anyway. So regardless, because this has not been something that we've had discussions with Fair Share Housing Center or the courts, this hasn't been approved of that 1 unit RDP. The assumption is the courts, whoever reviews this, whether there's any kind of challenger, Fair Share Housing Center, the New Jersey Builders Association, any developer who's looking to build something somewhere in the borough, they have the ability to challenge the plan, and they can challenge the real development potential calculation. In the event that somebody says, no, that number needs to be higher, we are satisfying the obligation regardless. And that 154 unit obligation, that is set by the courts already. That's been accepted, so no one can challenge that number at this point. And the way we are satisfying the fourth round obligations are through the Locust Landing project on the west side of the borough. That's an existing affordable development that was funded initially by Middletown across the river, had provided money to Red Bank to build affordable housing here. And as such, Middletown got almost all of the credits in their prior round plan for this project. Well, the affordability controls at Locust Landing were initially put in place for 30 years, and those controls are going to be expiring relatively soon. And Locust Landing has approached the borough. They need to do some upgrades to that facility. And if we contribute financially to the upgrades of that facility, we can claim credits for in exchange for them extending the controls. They would sign a further deed restriction on that property, so it would be affordable for another 40 years. So essentially the existing affordable apartments over there can stay, and the borough would get credit for it now instead of Middletown. We'd also potentially be eligible for bonus credits there, although since we can't get bonus credits right now if the RDP is 1, but in the event that RDP gets bumped up, then we could claim bonus credits for extending controls. The Globe Court project was 6 credits. The Vista project is 5 credits. The 121 Monmouth Street project was 7 credits. The Thrive Red Bank Special Needs project includes 5 affordable units. And then I think the redevelopment plan you were just discussing, I think you just adopted a resolution. I think it's called the Rail North and South right at the train station. I have that in the plan right now is 80 credits, although my understanding is when we had originally drafted this plan, that was supposed to be 400 units. That's come down to 350 something. So the number of credits we get from that would ultimately be determined by how many units are there, 20% of that. So this number might go down from 80 to 70, but that's still enough credits to satisfy the obligation. So we have in the plan, at least right now, 143 full credits, which satisfies that 1 unit RDP by quite a lot, as well as what the law requires is if you do adjust your obligation down from the 154 and we said down to 1, you also have to plan to accommodate at least 25% of the remaining unmet need. And we're more than satisfying that through these projects here. And that doesn't even include the potential for claiming bonus credits, which we would be eligible to claim up to 38 bonus credits if the RDP goes away. So just through projects that have already been approved by this board or the zoning board and other projects in the pipeline, which now the redevelopment plan, I understand, has been essentially endorsed by this body. And I assume at some point soon it'll go to the borough council where they will have the ability to adopt that as actual law. You're already fully satisfying your 4th round affordable housing obligation. And then one other component, the obligation, that's all prospective need. That's really the important part. There's a second component of the need known as the present need or rehabilitation obligation, which means there's an estimate based on census data, which can vary widely. It's hard to say how accurate that data is. But the borough has a present need obligation of, 54 units. And that's the rehabilitation obligation. That means it's an estimate of homes in Red Bank that are currently code deficient in some manner, meaning that they might need a new roof, they might need a new HVAC system. Hopefully, there's no one out there right now who doesn't have air conditioning with the way the weather has been this week. But an estimate of homes that are currently code deficient in one way or another and are also likely occupied by a lower moderate income household, meaning that somebody who makes, or not somebody, a family, a household, however many people there are there that are currently earning 80% or less of the area median income. And that means for Monmouth, Mercer, and Ocean County is this region, Region 4. So you take the average household income across the region. Any household making 80% or less than that is considered lower moderate income housing, and that or household, those are the people who qualify for affordable housing throughout the state. So your obligation there is 54. And to satisfy that, essentially, we would continue. You already have a borough operated rehabilitation program. I don't recall off the top of my head how many homes have been rehabilitated in the last 5 years through that program. I want to say it's about 10 to 15 maybe. But we're going to continue that program. That program is funded by the Affordable Housing Trust Fund, as well as Monmouth County has a rehabilitation program that borough residents are eligible to participate in. Through those two programs, we were proposing we will satisfy the rehabilitation obligation, although the level of scrutiny placed on hitting those exact targets is a bit less than the prospective need. The prospective need is you have to specifically plan for that and demonstrate that you have realistic opportunity for construction of those units. Whereas the rehab obligation is you just have to have programs in place and show that you're making a good faith effort to provide funding as necessary to make sure that those programs are available. But if in 5 or 10 years, we have not gotten all 54 units rehabilitated, we're at, say, 52, you're not necessarily in jeopardy of losing any immunity to builders remedy lawsuits there. But we do have to have a plan in place to make sure we're addressing that as well. And that's mentioned in this plan. So the next steps, like I said, to some degree, my hope is that this process will be a little smoother than the third round, which I said took 10 years of going through the courts. And even just with Red Bank, once the numbers were finally set, it was still several years of going through the courts. End of this month, by June 30th, every town has to submit their plan to what's known as the program, which is essentially just an arm of the courts that will be reviewing these plans, as well as I assume DCA will be involved in some capacity because the amended Fair Housing Act says DCA is supposed to take over the role that COA used to function as. There is then a 2-month window where any interested party is allowed to challenge the plan. So like I said, whether that's Fair Share Housing Center as an affordable housing advocate, the New Jersey Builders Association, which challenged a lot of towns when they adopted their numbers, or any developer or any other housing advocacy group or individual, they can challenge this plan and they can say, we don't think that this plan is providing a realistic opportunity for affordable housing. We have a better plan, and we're going to tell the court that we think different properties are better suited for affordable housing production rather than this plan. The 2-month window where anybody can file a challenge, and then whether there's a challenge or not, the plan goes through the program where a judge will review it along with used to be called special master. Now it's I think they call them court appointed adjudicator, something like that. But some expert in affordable housing will assist the judge when they review this plan, and they'll make a determination as to whether or not they agree with me that it is fair to the regional needs of the low and moderate income housing population, or if they think some changes need to be made. But I do have to stress, I think Red Bank is on very good footing with this plan, as opposed to many other towns in New Jersey. We're not talking about randomly picking out properties and saying we're going to zone them for affordable housing. Everything in here is a project that either are already constructed or already approved, or in the pipeline where there's already a developer who says, I want to build X amount of affordable units there, so that we can justifiably say that there is everything that we're proposing will be affordable housing is already in the pipeline, and it's not just hopes and dreams that somebody's going to come build something. So even in the event that somebody challenges, I think this plan could withstand a challenge. Now, everything in affordable housing in New Jersey for the past 40 years has been constant litigation. So I can't say for sure exactly what's going to happen. It's always been a very legally driven process rather than a planning process, but that don't really have any control over that. But I do, in my opinion, this is fair to the needs of the low and moderate income household population for the entire region, and satisfies your obligations under the Fair Housing Act. And I do have to stress this essentially does not even require that the borough do anything other than what it's already been doing for the past 5 years. And that essentially concludes my presentation here. Like I said, I wanted to do a brief overview of what affordable housing is and how we're satisfying our obligations. There's a lot of stuff in here. Like I said, there's about 10 pages or so of going over the obligations that are what the court is going to be reviewing. So that being said, I'm happy to answer any questions now.
Anyone on the board have anything, any questions? I'll open it up for the
You certainly may.
public. Anyone in the public have any questions? Well, that's a strange. Okay, thank you. Very interesting and oh, God, I'm sorry. It's okay. Don't, but you didn't turn it on. Thank you.
Thank you.
Is there anything you need from us or anything you?
We need a vote.
We need a vote.
Adopt the plan and as well as adopt a resolution tonight.
Yes, and there's been a resolution already prepared and given to the board, so you can make it, if you want to make one motion to adopt both the plan and the memorializing resolution, I'm fine with that.
Emotion.
We need a motion,
I move it, yeah. move it.
both. Is that for both?
Yeah.
Both.
Yeah.
Thank you.
And a
And
second.
a second? Second. Thank you.
Okay.
Roll call?
Christina Bonatakis,
Yes.
Lou Demento,
Yes.
Barbara Boas.
Yes.
Megan Massey,
Yes.
and Fred Stone.
Yes.
Thank you.
Thank you.
Thank you.
Motion to adjourn.
Yeah.
Motion to
Yeah, I have a motion to adjourn?
This feels rather anticlimactic for something that is very, very, very interested enough and thank you.
Yeah, and it has to go to court now, so we'll see what happens in the fall.
Right?
But there's protection at this point, so
Yeah, it's
you
good
got
to
your
know
shield.
that we are in, like you said, such good standing.
I actually have a question to ask, if I may. 2 minutes, 2 minutes.
Okay.
You were talking about you keep hitting the wrong one. We're having a fight over the buttons. You were talking about the rehabilitation. All right, my question is, how is that advertised to the people
I
who
can
may
answer
need
that.
them? Okay,
So, the previous administrative agent, I think Affordable Housing Corporation, they advertise it through their website and also, through the church. Pilgrim Baptist, also they sent it out, so there is posting, at the library. We post it here in Borough Hall, so, and just spread a word of mouth, so it is there, it has been advertised.
yeah, okay.
What I can say a lot of towns have done, because it's tough to know about these things. Especially, I mean, the county program is out there, but unless you search Monmouth County Rehabilitation Program, you might not know about it. But typically what I've seen towns do is when there's like an annual mailer of like your property tax bill, things like that, you can just stick a flyer in there that says low-income households, you're eligible for this program.
Thank you.
Okay,
Now
so
a motion to adjourn.
motion.
No motion to adjourn, I'm sorry.
Motion to adjourn. Second.
All in favor?
Aye.
Thank you, everyone.
Thank you.
Thank you.
July 9th or whatever the date that was.